Hello, Hare Krishna, everybody. Thank you for coming to this very important session of advanced care planning. I'd like to introduce Jennie Lyons. She was actually a former colleague of mine from Haven, and Claudia. She's taking care of the access department now. And that means people coming into Haven. She's like the point person for that. So the director of that. And Jennie is a head social worker. She's been there 7 years and knows everything you want to ask about legal aspects of care. And she'll talk about wills as well because she's very knowledgeable in that. So she'll do the living will plus the healthcare surrogate and touch on other nuances that we run across in our community with single people who don't have next of kin and what to do, or if their kin is somewhere across the other country, what to do. So those kind of issues. So Jennie, thank you very much.
Thank you for having me here. It is a pleasure to be here to share this information with all of you. Advanced care planning is one of those things that a lot of people don't think about until they really need it. And then sometimes it's too late at that time. And so I like to say that it's important for you to let others know what your wishes are, no matter what your situation is, whether you're healthy, whether you're young, whether you have some health conditions, whether you're facing a life-limiting illness, whatever the situation is, it's always a good idea for you to have a plan in place of what you would want for your care and to ensure that others know what those wishes are. So advanced care planning gives you that opportunity to think about what you would want, when you would want it, how you would want it, but also in the event that you're not able to make decisions, who that person would be. So there are a couple components to advanced care planning. It's not just about a conversation with somebody who you want to know your information about if you were in a car accident or if you had a sudden health event or even if you had a chronic illness. It's about also documenting all of that information so that it's available in the event that something does happen to you and you can't voice those wishes. It tells others who you would want to be making those decisions, who they should talk to, but also it tells what you do or you do not want. In addition to, and we're going to touch on this because it's kind of important, especially if you don't have a lot of family or your family is distant. So advanced care planning is a part of what you do to have your affairs in order. But in addition to that, there's the financial component, which would be a durable power of attorney. So in the state of Florida, if you're unable to make your financial wishes known, if you do not have somebody who, say, is on your bank accounts or who can sign contracts for you, and something happens, you're not able to access that and you're not able to make those decisions, then a durable power of attorney allows somebody who you designate to act in your stead. So it gives them a lot of, or very broad authority, or it can be very minimal authority. But a durable power of attorney stays enacted up until your death. At your time of death, though, that document ceases to have any type of authority or power. The same as your advanced directives, such as your healthcare surrogate and your living will. All of those documents cease to have any legal authority at time of death. The one document that does have authority post-death is a last will and testament, which designates somebody as your executor or your personal representative. What that does is it moves to your estate, and they're the ones managing your estate and the decisions for your estate. And your estate can be as big or as small. It could be as simple as a bank account or as complex as homes, other properties, trusts, all of those things. Wills should really be done through an attorney. especially if you have a more complex estate. And that is because they know all the in and outs of the current laws, because laws change consistently across time. So for example, in the state of Florida in 2012, a law was passed that automatically removes ex-spouses from any property inheritance and life insurance inheritance as beneficiary unless you redesignate after that time frame. So it's really important to have an attorney who knows what the current legal statuses are in order to do a last will and testament. And that deals with your property. But going back to your advanced care planning. So one of the big pieces of advanced care planning is your healthcare surrogate. Your designation of your healthcare surrogate, it is portable across state lines. So if you were to be in Georgia and were in an automobile accident, your healthcare surrogate could present this form and they would be able to make your healthcare decisions, whether you were in Florida or another state. Other states honor your advanced directives from this state. There's only one that they do not honor, and that is the do not resuscitate order, and we'll talk about that in a little bit. So the healthcare surrogate form, it's actually 2 pages now. It used to be 1, and it's because it's become more enhanced and allows for HIPAA release. So there is a section that can be initialed that allows the person that you select to make your healthcare decisions to have access to your protected health information, either immediately or after you're no longer able to make your own healthcare decisions. In addition, there is a section now within the healthcare surrogate that allows your healthcare decision maker that you designate to make decisions effective immediately or only after you become incapacitated. Where this is beneficial is if it is a trusted person and you may have a difficult time making decisions for whatever reason, you can defer to your healthcare surrogate, but your decisions will always override what anybody else chooses, even if they are your healthcare surrogate. The healthcare surrogate form also allows you to name an alternate. So in the event that your primary healthcare surrogate becomes incapacitated or dies before you, or for some reason refuses to act as your healthcare surrogate, then the alternate can act in their stead. Why this is important is if your healthcare surrogate is somebody who you are frequently with, frequently travel with, and there is an accident, if you and your primary are both incapacitated, then who makes your decisions? Because without a healthcare surrogate, it follows in the state of Florida, and each state has their own decision-making statutorily set out of who makes decisions if you do not have an advance directive in place. In the state of Florida, it is, if there is no advance directive, the first is a court-appointed guardian as long as they've been appointed to make healthcare decisions. That is not the most common thing to have happen. Most people do not have a court-appointed guardian for healthcare. The second would be your spouse. After that, it is your adult children. And when it is adult children, it is the majority of your adult children. So if you have 3 children, 2 have to be in agreement. If you only have 2 children, then they both have to be in agreement for the decision. So it can be complex, and that's part of why this is also helpful to have somebody designated. After your children, then it is your parents. If your parents are no longer alive or available, then it becomes your siblings. And just like with children, it's the majority. After that, it is an adult family member, and it can be any adult family member. After that, it is a friend who has special care or concern or knowledge of you and your wishes. In the event that none of those can be located and you're at a hospital or a facility, then their bioethics committee can appoint a professional healthcare surrogate who is a licensed clinical social worker not affiliated with that facility to make your decisions on your behalf. So this is really important because it may not be the person that you would want to make decisions for you if you were to go by law, which would be the proxy law. You may be separated from a spouse. We have run into that frequently where they're still married. Florida doesn't have a legal separation. So you're still legally married and that person still retains all rights as an active spouse. So it's always helpful. You may have multiple children. You may not have family that you want making decisions, or you may not have family. We run into that frequently. So it's always a good idea to have somebody designated of who you want to make your decisions. The next part of advanced care planning.
Can I ask you?
Yes.
The first person that's designated, a court person before the spouse?
So yes. But that is a rarity because typically in order to be appointed a guardian, there has to be a very significant reason of why you are impaired and cannot make your decisions. And most individuals who have guardians typically don't have spouses.
So this kind of overrides all that.
This overrides the proxy in its entirety.
Thanks.
Yes. So the next part of advanced care planning.
Yes. Also, healthcare surrogate, your, what do they call it, power of attorney?
Yeah, they can be the same thing. However, in the state of Florida, your power of attorneys by statute, unless they explicitly include healthcare, do not include healthcare. So even if you have a durable power of attorney that states that your attorney, in fact, can make all decisions related to your person, it does not include healthcare decisions. It has to explicitly include it. Florida is one of the states that by statute omits that. It has to be an explicit, you have to include it explicitly.
Can you clarify the difference between a power of attorney and a durable power of attorney?
Yes, so a power of attorney there are many different types of power of attorneys. A power of attorney is typically one that ceases to have any authority upon your incapacity. Whereas a durable power of attorney, that authority continues until death or until revoked or rescinded. Most of the time when a power of attorney is used, it's typically a very short term. For example, when I was in the military, I had a power of attorney for my mother to take care of my car registration because I was stationed in Nevada, but I was a legal resident of Florida. So the power of attorney allowed my mom, it was very explicit, it only allowed for her to handle the registration of my vehicle. And so most power of attorneys are short and they're typically laid out for a very explicit reason. But they will cease to exist unless there is a clause that is in it included, making it a durable power of attorney that continues regardless of your ability to make decisions.
And if you became incapacitated, that power of attorney for the car would have ceased.
Correct. Correct.
Yeah, one other clarification.
Mhm.
So are the healthcare surrogates, you said it's okay to go across the state lines, but what about country?
So, most countries have their own way of doing things and their own legal documents. A lot of other countries will honor, but they do not have to.
So does the US honor a healthcare surrogate that's assigned, say, in England?
We typically do, as long as it meets some of the requirements. So in the state of Florida and most states, there are some states that your designation of healthcare surrogate has to be notarized. But the majority of states, as long as they're witnessed by two people, neither of them being the representatives named, as long as it meets those types of requirements, then typically the physicians in the United States and healthcare providers will honor them.
And then if your family is out of the country, you know, when they go down the line, that spouse and children. So if you don't have any family or you haven't been in touch with them since 40 years, say, or they're out of the country, can you talk about those two situations?
So even if you haven't been in touch with them, if during the search for them, we can locate a phone number, we will attempt to reach out to them. Any healthcare provider has the obligation to attempt to locate what would be the next of kin or the proxy. And so even if you haven't had contact, then they could still make your decisions. We had an individual who has just recently come onto our services and had not yet executed any advance directives. He was still completely alert and oriented, knew who he was, knew what he wanted, could execute his own wishes. And he was separated from his wife and had been for over 6 years. He did not know where his wife was currently. However, when we located his sister, she had a telephone number for his wife. And so we did with him, when I went out to visit with him, I asked him who he wanted to make his decisions, what and everything, how he wanted his healthcare, and he did complete a healthcare surrogate. But had he not, when the time came that he could not make his decisions, we would have had to have called his wife, who he had been separated from, and she would have been legally making his decisions, as long as she did not defer. Now, if she had said, I don't want anything to do with this, I'm not making his decisions, then we would go to the next, which would have been at that time his children, and he does have a daughter.
And if they're out of the country, that's still okay.
It's still okay. We will, as long as we can reach them or contact them, although sometimes it can be very difficult because of international phones and time differences. Sometimes we are not able to successfully reach. And so if you make them your surrogate even, and we're not able to reach them, then we go to your alternate in the event that it's an emergency and we need a quick decision.
And do these rules apply to giving authorization for cremation as well? The same
No.
rules?
No. Now, most healthcare surrogate has a clause that allows, not all, could allow for assisting with final arrangements prior to death. Durable power of attorneys give that their attorney, in fact, give that permission unless it excludes it. The other thing that you can do is if you make your pre-arrangements, you can actually, most funeral homes, and you can download some of them online, you can self-authorize your own cremation.
But if you don't?
But if you don't, then it would be your legal next of kin at time of death.
Which would be the same rules that you explained?
Yes.
Unless what you just said before that was.
Unless the arrangements were made prior to your death. So for example, you were in the hospital and you were very close to end of life and your power of attorney or your healthcare surrogate contacted a funeral home and went ahead and signed for the authorization prior to your death. Then it would be a valid authorization at that time.
Okay, so the durable power of attorney at that point, when you're in the hospital or you're getting close, can sign for you?
Can sign for the cremation, yes.
Mm-hmm.
They can make all of those business type transactions unless it's excluded in the power of attorney form. So, yeah, ideally though, if you don't have family, if you make pre-arrangements of some type, you can pre-authorize and sign for your own cremation.
Well, the problem is sometimes in this particular community, some people like to go to India, for example.
Yes.
So in that case, it wouldn't apply, I guess.
And probate, so the other issue with, once you pass, it is where you are located at when you pass is where your estate would need to be finalized. So if you were in India and you had a last will and testament, it would need to go through the Indian courts.
Your will from here would have to go to the Indian.
Yes. In addition to if you had property here, you would have to go through probate here also for that property. So wherever it is that you have property, whether it's an account, physical property, whatever it is, wherever you're at, that area covers that property and probate, but where you also die could cover you would have to do your probate there. That's why an attorney is very important for a last will and testament, because they can address any of those things that could happen. So if you might be going to India for your final days, then you can have an attorney that is familiar with international probate to help protect you. You're welcome.
So best to really leave your good property to whoever before you die.
So a lot of property, whether it is a bank account, a retirement account, life insurance, even land, you can designate a beneficiary or a transfer upon death. And those typically do not go through probate. They automatically transfer to the new owner, the person that you designate as the beneficiary or the transferee. Yeah.
So nothing's taken out of it.
Right. And it doesn't even go through probate. It's something that just automatically transfers to a new owner. Yeah.
Well, if it's a joint account, then it just goes to the
Yes.
other person.
Yes. The beneficiary on a joint account would only receive it once both individuals on the account were deceased.
So you do that in a will?
You can do that. Most property allows you to name a beneficiary. So like your life insurance, you can appoint a beneficiary and an alternate beneficiary. Sometimes you can appoint multiple beneficiaries and have it pay percentage to each one, or it will transfer to the first one. If that one, they can't pay to that one, then it transfers to the next. And so most financial accounts of any type, whether it's a retirement, a trust, a checking account, a savings account, they have the ability to designate a beneficiary who would then receive it with a copy of the death certificate. Property, like a home, a lot of times you can have the title or the deed set up to transfer upon death to a new owner. So if you have a friend or a church or a family member that you would like for it to transfer to upon your death, then it's a special type of deed that allows it to transfer upon death.
Is that called a ladybird or something like that?
I'm not sure. I know it's a transfer upon death.
And that's separate from your will and testament.
Correct.
Okay.
Correct.
What can't you say in your will and testament? You want your house to go.
Yes, you can. But your will still need to go through probate. So if you list it in your will, an attorney can better answer that question. But if you list it in your will and it goes through, it will still have to go through probate. In addition to with probate is anything that's not designated through a beneficiary, what happens is in the event that you have unpaid debts, your property may have to be sold in order to pay those debts. And then anything left will be dispersed to your heirs that you list.
Whereas if you may put a beneficiary to your house, then that wouldn't.
It doesn't go through probate at that point. It's a transfer.
So even if you have a will, it still has to go through probate.
It not necessarily full probate, but it will still have to be, the will have to be presented to the probate courts. and a judge will have to agree to confer the executor to become the legal representative and to dispose of the estate as described in the will.
But if you
Yes.
name a beneficiary before you die.
Then it goes to your
Then you
beneficiary.
don't have to worry about any legal entanglement, anything like that. or-
Not normally. It's always good to consult an attorney when it comes to property sale.
They would probably have to pay legal fees and all that stuff.
It depends on the type of property it is. They may have to pay taxes, they may have to pay a transfer fee, but an attorney can answer those types of questions.
Thank you.
Mhm.
Well, even if you have the beneficiaries, like you're saying, people can say, oh, I took care of everything, I don't need a will. Do you need a will then?
That would be a question for an attorney. Seriously. And I say that because there may be those little nuances that we aren't aware of that could come up. And so it's always good, it really is, it's always good to speak to an attorney. The Three Rivers Legal Services is the community legal services for all these counties throughout here. Yep.
Legal service.
There's also, okay, Lieberman, he's doing that now in our community.
A lot of attorneys will offer a free consultation or a very affordable consultation to discuss and for you to ask questions without having to actually do a retainer. Yeah. You're welcome. So the next aspect to those is really laying out what your wishes are. And you can do this through a living will. Most living wills, and this is the language that Florida statute also encourages, is used for a living will. It typically only goes into effect, and you can mark which category or all that you want. If you are diagnosed with a terminal condition, which typically means that you have 6 months or less left to live if your disease were to run its natural course. And typically 2 physicians make that determination, especially to enact your living will.
Which one?
The next is if you have an end stage condition. So say you have end stage renal failure, so you're in kidney failure, or your liver is failing, or you have another form of an end stage disease. And the other category is if you're in a persistent vegetative state, and that is always determined by physicians and typically through medical testing. Once you make that determination of when you would want that to be in place, things that are typically covered in living will is whether or not you would want mechanical or manual resuscitation of your heart, which would be CPR. And we can talk more about CPR if you'd like. CPR is not, a lot of people don't realize how CPR came about. It was actually designed for use with emergency conditions. So it was designed for when your heart was stopped because of an accident or something that triggered it. So whether it was an electrocution, a car accident, something that was not disease related.
What does it mean? CPR?
So CPR is cardiopulmonary resuscitation. And so that is typically when they do chest compressions because your heart has stopped. So when your heart has stopped, then in order to try to preserve life, they will initiate certain things. And so cardiopulmonary resuscitation includes chest compressions, and a lot of times artificial breathing. So you may end up intubated, which is where they put a tube down your throat into your lungs and manually breathe through for you with, like you've seen on TV, how they have they talk about bagging someone and they're squeezing a bag to help them breathe, or through mouth-to-mouth resuscitation. which is not the common anymore. In fact, most CPR, except in a medical setting, typically does not call for rescue breathing anymore. It typically just calls for very rapid chest compressions. So that's the other part of CPR, is that they are going to do chest compressions, which the goal is to squeeze your heart between your sternum and your spine so that it will manually squeeze and pump blood, so that it will you'll continue to have blood flow throughout your body. Or they may use a ACD, which is the electronic, you've seen it on TV where they use like the paddles or the pads, and it shocks your heart into to try to restart a normal rhythm. CPR is not, it's not what it looks like on TV. I wish it was what it looked like on TV. It's very violent on the body. It's very traumatic to the body. It may be successful. Unfortunately, for those that don't suffer certain types of events, it's not very successful. Yeah. So one of the next things that it talks about is intravenous or gastric feedings. So artificial nutrition and hydration. So in the event that you're no longer able to eat when you have one of these conditions at the top, then would you want a feeding tube or a tube run up your nose and down into your throat to provide you with nutrition? This would not be you were in a car accident and you needed some artificial nutrition and hydration while you recovered. This, a living will, is only when you have the top conditions. And so that's also why it's really important to have conversations and sometimes write down your notes, and you can attach them to your living will. You have the addendum that also applies for all of you. Living wills are binding agreements in the state of Florida. We do not violate a person's living will once it's enacted.
I have a question. So there's three conditions.
Yes.
Terminal condition, end stage condition, vegetative state. But the first one, sometimes the doctors could be wrong, right? They say terminal disease, you have 6 months to live. Or, I sign up this DNR and, I had more than 6 months to live.
So when we'll talk about the DNR, all of these documents are what we call living documents. They can be changed, they can be revoked, they can be modified at any time, as long as you still have decision-making capacity. And ideally, you will have decision-making capacity. If you're still alert and you're still able to make some wishes and needs known, it would take two physicians to determine that you no longer have that capacity. Now, if you're in a coma or you're not able to communicate and not able to make your wishes known, then these documents can't be modified at that time.
And the terminal illness can go on for years.
I know, I live,
Years.
I work for Haven Hospice, so I know.
Yeah, they can.
Years.
Yeah.
So, and then the last one is mechanical respiration. So in the event that you're not able to breathe on your own, would you want to be connected to either a ventilator or a BiPAP, which is a non-invasive forced air to breathe for you? And it's a mask that goes on the face. It's not the same as a CPAP that you have if you have sleep apnea. It's not the same thing. Or in the event that it becomes longer term, they may put in a tracheostomy, which will then be connected to something that will help you breathe. So those are options. Now, most living wills, to include this one, has a section for additional instructions. And so you can add anything to that. So for example, if you never want to have dialysis, you can write that in. You can include that you do not want dialysis. Any amendments you can have added to your living will, which brings us to your addendum. So your addendum, if you so choose, and we encourage you always to have your any addendums signed and witnessed. They do not have to be notarized. So sometimes that third component of your advanced directives is what we call a Florida do not resuscitate order. Now that is, it's a yellow form.
Can I just ask
And
you before you go on?
Mhm.
I'm sorry. This last page.
yes,
So, you can either keep this or change it in any way that you like, right?
Yes.
And, they can
Yes.
even do a whole another page.
yes,
And, it just needs to be witnessed or not?
it should be witnessed,
It
yes.
should be witnessed.
If you're gonna addend your living will, if you're gonna make an attachment, like an appendix to your living will, it is always encouraged that it is, that when you sign it, it is witnessed by two individuals to attest to its validity of your signature. Because that's all they're witnessing. They aren't witnessing what your wishes are. They're only witnessing that it was you who signed it. That's-
Witnesses, they have to put the printer name and sign it, or they just sign?
Yes.
Ideally,
The witness.
you sign and print your name.
What about them?
The witness, they just need to sign their name.
Okay.
Yep.
Well, I have that printed today because otherwise.
Sometimes it's
just
very-
like that. you
Yes,
know?
sometimes it's very difficult to read a signature.
Yeah, exactly.
And in the event that the validity of it, of your signature, if this is your document, were to be called into question, then they can contact the witnesses who signed and witnessed you signing it to verify whether or not it was you who signed it or someone else.
So they should sign this one and the other one.
Yes,
right?
both should be. Both should be signed and witnessed. Anytime you addend your living will, whether you completely do a new form or you do an attachment, like your addendum, you should always have it signed and witnessed. I would also encourage you, anytime you do these, that your healthcare surrogate have copies of them also.
And nothing needs to be notarized.
Nothing needs to be notarized. The only thing that would need to be notarized is your last will and testament and any power of attorneys, whether it be a standard or durable. Those require notarization. And all a notary is doing is notarizing for a durable power of attorney, or power of attorney is also notarizing that it's your signature. They're not notarizing that the information is true and correct. They're just notarizing that it's you who completed this document and that your witnesses are who they say they are.
So that was an important point you mentioned at the end, that you should give these papers to your healthcare surrogate,
Yes.
or even your children, you know.
Whoever it is that you feel would benefit from having a copy. So whether it's your healthcare surrogate, it's your physician, it's a community individual who you trust to know and be able to say, wait, here's their documents.
And not put it away in a drawer or a safety deposit box.
Please don't put it in a safety deposit box, because if you're the only person who has access to that, then what happens when there's an emergency? Right. So it's always good. It's also something that you should review anytime there's a change in your, whether it's your health, who you want to make decisions, what your wishes are. When we're young and healthy, the concept of having your heart, having CPR done, or having dialysis is a very kind of a foreign concept, right? But as we start to have some health problems, or if we're faced with something like cancer or maybe a heart attack, we kind of will start changing the way we look at things. And so it's always a really good idea when you have these conversations is to think about what is acceptable outcome and what isn't an acceptable outcome. So for example, if you are okay with, no matter where you're at in your disease process, if you're very sick, if you're okay with CPR and the possibility of being put on a ventilator, then that's okay. If you don't want that to happen, then that's what your living will document. That you don't want your heart restarted, that you don't want CPR done. So, think about conversations you may have had with others when you've had a family member or a friend who's had something happen and they've said, and you've thought, oh God, don't ever let that happen to me. I don't ever want that to happen. I would never do that to someone I love. Think about when you've had those thoughts. And so those are what we would call those hard lines of things you don't ever want to have as an outcome. And you can use those to help guide you also when you make your choices.
The date on, let's say, someone's not ready to do that addendum right now. Can the date be different on
Yes.
this part
Yes.
and then the addendum can be different?
Because the addendum is like an appendix.
Yeah.
So it doesn't replace, it's an addition to. Yeah. Yes.
These three things are covered, the heart stopping and reviving it, and gastric
Mhm.
fluid, and the breathing.
Yes.
What about the fourth thing? If you want all these things to be done, but you're actually brain dead, when, the ultimate
So-
outcome should be pull plug. Where's the pull plug part?
That is, so if these things are being done, say you're in a car accident and you still have brain activity and they ventilate you and they've restarted your heart and they're giving you artificial nutrition, and then in a month you've not come out of that coma, but in addition to not coming out of that coma, you've progressed and now you don't have any brain activity. So this, at that point, you would not have to, or your decision maker would only need to present as long as you said you do not, if you're in a persistent vegetative state, because the other two categories at that point wouldn't apply. It would only apply at a persistent vegetative state.
Oh, that's on the top here.
Yes.
There's just, there. Third.
Yeah.
Okay.
You're welcome. So it's always a good idea to review them anytime you have a change in your health, anytime you have a change in who you want to make your decisions, or anytime there is a change possibly in who you've already chosen to make your decisions. Because what happens if the person you've selected, either you have a falling out with them or they tell you they don't want to do this. This isn't what they want to do. Then you need to revisit who you're appointing and what your choices are. But also, if none of those things apply, it's always a good idea to review them at least every 5 to 10 years minimum.
Your decision maker could move away.
Yes, yeah. So the last part is really the Florida Do Not Resuscitate order. And so what that is it is the legal document that prevents CPR from being performed in the event that your heart were to stop. Now, there are inpatient do not resuscitate orders, and those are only valid in a hospital setting or a clinical setting. The order that you see on the yellow paper, and by Florida statute, it has to be on yellow paper. It cannot be a photograph, it cannot be on white paper. So that form is a physician order sheet. So it is not valid until it is signed by a physician. But what that does is say that you have cancer or you have really bad heart disease and you're at home and your heart were to stop and you have this form in place, it can be presented to EMS or a medical professional when they arrive, and they will not start CPR, meaning they will not attempt to restart your heart. That it will allow you to have, I so much prefer that instead of do not resuscitate, it will allow you to have a natural death at the natural end of your life. When your heart stops, your heart stops.
I have one from a previous meeting, but I don't see any yellow pages today. Are you passing these out?
They were not included in them. However, if it's entirely a choice that you can make with conversation with your physician, I would always encourage you to have a conversation with your physician of when would be the right time to initiate a DNR.
But where do you get the paper?
So they can be printed online. They're available free on the Department of Health website. You can,
Yellow paper.
you can get yellow paper anywhere. It's as long as it's yellow.
Yeah.
It doesn't have to be that golden yellow. It can be any yellow. So it can be light yellow, it can be dark yellow, any color yellow. It just says yellow.
What's
Doctor
the,
signs it twice.
what's the legal ramifications if, like, you go into the state and then your caregiver just waits till you die and then call the,
So, I have been present for those situations, because we have, as a social worker with hospice, and I go out into homes also. And so I've had that happen where the caregiver, knew that myself and the nurse were coming for a visit, and so the patient was still full code, and the caregiver chose not to call 911. And so when we got there, the gentleman was deceased, but we still, at that point, had it appeared sooner than what it had, the nurse would have initiated CPR, and I would have, while I was calling 911. In this instance, we still had to call 911. EMS still had to come out. They still had to verify that the individual was deceased.
But generally, when somebody's on hospice, they have to be DNR.
So the state of Florida says you don't have to have a DNR to have any type of healthcare. However, it is very beneficial when you're on hospice, because CPR is typically not successful and can increase suffering. Because even if they do restart your heart, typically you also have broken ribs, a multitude of other issues that have happened, to include anoxic injuries, because you've been without oxygen. So you may not come fully back. You may not be the same person with the same abilities. And it typically only keeps death away for a shorter period of time. It doesn't actually prevent death from occurring from your disease process in the future.
So they're not requiring DNR for hospice.
No. We encourage it, and we talk about why. And but it is always, the Patient Self-Determination Act allows you to make that choice yourself. Or in the event, the DNR is one of the advanced directives that can be completed by someone else when you no longer have capacity. We encourage it for those that are in hospice, that are terminally ill.
They encourage you to have that.
Yellow form.
Right.
So you gotta come on your-
Yeah,
Doctor
we
signs it twice.
He's not saying.
So the thing about that form is the bottom is what we call a portable version. Mhm. So you can put it in your wallet.
Yeah.
Yes. The other thing that I encourage you to do with your advanced directives, and a lot of people haven't thought about this, is make copies and put them in your glove box
The copies on yellow.
of any of your advanced directives, and keep them in your glove box.
You
So
said it
you're
has to be
living
yellow.
Because in the event that you're in a car accident,
Just that form.
I would encourage you, your living will and your healthcare surrogate also. And the reason being is, if you're in a car accident, law enforcement and EMS will always check your glove box for identification. And so if you want these followed, and if you're not able to tell them what your wishes are, they will have copies of them. I know that sounds a little weird. But it's just one of those things that if you want to ensure your wishes are followed in the event of an emergency, then they're not trying to search through your phone and calling random people for who they need to notify that you've been in an accident and that you're being taken to the hospital.
One of our devotees the other day gave me a ride. She has a DNR sticker on the glove box. So you could just see it right there.
So there is
Of course, the
some
papers are-
controversy regarding people that are getting tattoos or with jewelry. Yes, there is some controversy around that, and that is not they do not have to honor those items.
Oh, okay.
Yeah,
It's not the document.
right, it's not in the document, right.
Yeah.
That's fun.
But is there different degrees of CPR or
There is not.
there's not?
No, they're either going to do everything to restart your heart or they're not. It's, you can't say, I want 5 minutes, and if my heart doesn't restart, then stop.
Really?
Yeah.
You said the EMS will not try to do CPR, but they're just racing out to the scene of an accident.
So in an accident,
This person will they jump on the person to do something.
They will.
They don't
And-
check or
no.
call or
they do not.
they can't find it. They can't find
And
this.
that's why
Oh, they're
sometimes
different.
it's very helpful to have it in your glove box. Have copies in your glove
But they
box.
check the glove box before they do it?
No, they are not.
Okay.
It's because your brain's losing oxygen.
Yep.
So you don't want to.
You have seconds.
Yeah.
Yeah.
That's what I'm saying.
But if they
don't-
find
don't
it,
check.
then they will stop,
Yes.
depending on how far they've gotten. If they've already intubated you, then, at that point it's too late.
Well, that sounds like it's a different degree.
Yes, I guess
You
you
gotta
could say
check.
that would,
You gotta
that,
get
in that
checks.
instance, it could be a different degree.
Yeah.
Yeah. Once CPR is initiated.
Yeah.
It takes a physician to tell them to stop,
Oh,
unless there is a DNR in place.
it'll
And,
go on
and
for a half hour?
so,
Sometimes,
sometimes, yes.
Really?
sometimes.
Yeah.
Very,
it's
very
like
dramatic.
Get tired or?
Yes. And trust me, you don't want a 250-pound person compressing your chest as hard and as fast as they can with a goal of 100 compressions a minute.
And then you take turns. I've been at,
You
I've
do.
been at it where we just keep taking turns.
Yes. Yes.
For what?
To try to
Get
To-
you out of here.
yeah, to keep you alive.
Result that you still recommend that?
A brain dead
No,
person.
no,
right?
recommend to.
Not always.
No.
Not always.
Well, that's why they do 100, because they want the blood to go to your brain.
So let me share an experience with you. This is not a normal experience. This is an anomaly. My dad at 58 had a massive heart attack. Now, he had that heart attack after he had walked into the ER, and the physician was actually the first person who came to him. It was at the VA hospital. The physician was actually the first one. It was not a nurse. It was not a clerk. And asked my dad what was going on. And my dad instantly collapsed. He didn't have a chance to say anything. So that physician was actually a cardiologist. And they initiated CPR and all aggressive care. And they worked on him for almost 2 hours. This cardiologist would not give up because he knew the exact time that his heart stopped. He was intubated. He was put on a ventilator. They used the defibrillator on him 16 times. They used 2 full cardiac trays. He should have never survived this. And he should have never survived intact. But he did for an additional 20 years. That is an anomaly.
Yeah.
That's an anomaly. That is not the norm.
Yeah.
Normally, when your heart stops from disease process, if they bring you back, you might come back for a few hours to days to sometimes a few weeks to months. You don't when it's disease process, you don't normally, the ratio of survivability in the hospital is less than 10%.
Right.
And that's in a hospital setting. Because it really wasn't designed for natural death.
So there's disease and then there's some.
Electrocution, drowning, and
Yes.
accident.
There's no distinction either for that.
No, and that's why it's always a really good decision to speak to your physician about when to sign the yellow form. The designation in your living will would only come into play in the situations you chose. So whether you were terminally ill, had an end stage disease, or were in a persistent vegetative state, which is not going to include normally an accidental or an emergent situation. It typically is as you're naturally ending your life. But that's why the yellow form, it requires a physician to sign it, but it's always a really good conversation to have with your physician to determine when that really is the right time. Because for somebody who's healthy or even has some health concerns, now may not be the right time.
Well, shouldn't everybody just have it for the future?
It's
Rather than
always
sign
a,
it when you're well, later
it's-
you're too messed up to understand what's happening.
well, and that is one of the forms that someone else can sign on your behalf. So your proxy, your healthcare surrogate, or if your durable power of attorney includes healthcare decisions.
So what's a proxy? Can you clarify what a proxy
So the
is?
proxy is when you don't have anybody designated, it's that by law decision-making tree. So the first person was that guardian appointed by the courts for healthcare. Most guardians are only finance. They don't take away your healthcare decision abilities. And then your spouse, then your children, then your parents, then your siblings, then another relative, and then a friend who has shown care, concern, and knowledge of your wishes. And after that, then if you're in a facility, it is somebody a licensed clinical social worker appointed by a bioethics committee that is not employed by that organization.
That's if you don't have a physician in the city.
That is if you do not have a healthcare surrogate named. In the event that you don't have any advance directives naming who would make your decisions when you cannot.
So the yellow form, does that have to be signed by a physician?
That's the only form that has to be signed by
What
a
if you don't
physician.
have a physician?
If you don't currently have a physician,
Manning.
then,
Well, that means you're healthy, you don't need a physician.
right, right.
I know
So when
that,
you do
but,
need a
know,
physician,
that doesn't cover that.
So, and the other thing about DNROs is they can only be signed by physicians. They cannot be signed by physician assistants, nor can they be signed by currently a nurse practitioner. And each state, so some states have what's called a POLST, which is a physician order of life-sustaining treatment, and that does more than just the DNRO. That includes many other things. Florida does not currently have a POLST. Other states, some states do. So in the event that you were to move, I would always encourage you, that's a really good time to update any of your advanced directives.
Can I give you an example? So
Yeah.
we had a situation where there was an individual who elderly became sick and didn't have any family in the country. Didn't have advanced care directives. So, but somebody in the community was taking care of that person, day to day. But they would not allow that person to make any decisions.
The person themselves?
The person, once that person became, further along in that disease process, not completely, well, let's say they were incapacitated, maybe. The healthcare team would not allow that caregiver to make any decisions.
That to me is very unfortunate.
But because they're not family and they're not.
But Florida proxy law states that once you've run through all of those prior to a hospital and their next step or their clinic, their next step would have been going through their bioethics committee to appoint an LCSW. The step before that is a friend who has shown care and concern and knowledge of the individual.
But that
So they
situation,
should have.
But what they tried to do is try to find family, and the family was in another country.
Yeah.
Yeah, you have to try.
You have to try. If for some reason you cannot reach the family or time constraints, it is a true life or death emergency, you don't have time to try to find family that's, say, in France.
Mhm.
But you, after that emergent situation, they would have to actively search for family.
yeah, that situation that the family got power of attorney, but then they were not available to respond when he needed issues taken care of. And then the friend wasn't able to do anything because they said, don't let the friend do anything. So they had the power of attorney that blocked the friend from helping the person. So that was,
But was it a durable power of attorney?
I don't know what kind of attorney. It was a power of attorney, but the power of attorney. And they were very, and they even blocked his cremation. They did all kind of weird things, you know?
And that's why it's very important
Yes.
to document all of
He
your
should have had
wishes.
something like the friend set up to do this for him,
Yeah.
because the friend was more, but
Yes.
instead his family came in and took over, coerced him into it, and then.
Sometimes
Take care of
the
it.
person who you think will make good decisions is not always the one who will. And that's why it's really important to have a conversation with them. Or if you have a belief system that your family doesn't agree with, then perhaps it's best not to have your family making those decisions, because you want the person who is going to make the decisions that they're a substitute for you acting under your wishes. They should be making decisions that aren't in line with them. They should be making decisions that are in line with you.
Can you talk a little bit about how in situations like that, about cremation and authorizations?
So your authorization for cremation is if you can self-authorize. Now you can draw a notarized. I would recommend that be notarized. There are blanket authorizations, and then that can be utilized anywhere for cremation. And there are also ones that, like, their funeral homes have their own. If you donate your body to science, there's an authorization for that. So typically those authorizations can be very specific to whatever the company is that you're using. But there's also a blanket one that is very generic that meets the state requirements. And so those can be done prior to your death. You have the ability to self-authorize your cremation. Now, if you make those decisions, make sure that they're also the people that are going to enact those wishes have those copies too.
Can you put that in your living will that you want to be cremated?
You can put it in your living will, but your living will ceases to exist at time of death. So you can put it in your last will and testament.
And that'll be honored.
Yes. But the other thing you can do is you can draw up a separate document. You can have a separate document that outlines your wishes for your final arrangements and have that witnessed and signed also.
You mentioned earlier that there's some kind of a cremation authorization or something. How do we find out?
So let me
It's
check and
online.
see.
It's online.
It is,
Yeah.
but it's also something I think I have copies too.
Okay, maybe you can send it.
I can email it to you and you can send them out. Yeah. Now it's for Florida. So in the event that you're in another state, you would need to use whatever was authorized for that state. And that's why you could sign the self-authorization, but by doing a legal document for your wishes for your final arrangements, that's also a document that can be used for whoever's gonna be completing your final arrangements.
Well, how do we find that? Just Google it or,
No, I can give it to you, she'll send it to me.
Yes.
well, how does people don't
Well-
know you, how do people find it?
You can Google it. You can also, and almost any of your funeral homes have copies.
Oh,
But they have their funeral.
Some of them use the generic one, some of them use their specific form. It all contains typically the same information. Yeah.
I gotta go. Sorry.
So what should we do now?
So, because you have to leave first, did you want to complete any of your directives?
I can do that. I know I can do that and then what do we do with that?
So once you complete them, don't sign them until you have 2 witnesses.
Okay,
Sign them in front of the 2 witnesses.
and then what do we do?
And then I would encourage you to make copies, have your surrogate and your alternate, if you decide to name an alternate, give them copies. Also, if you have a physician, I would encourage you to provide a copy to your physician. Because in the event that something happens, and your alternate or your surrogate or your alternate doesn't have their copy, they know to have your physician send them
Okay. So basically you keep it yourself and give it to the people that.
and give copies, yes.
Your copies. It doesn't have to go to any legal.
No, it does not.
So Haven doesn't hang on to them anymore.
We do. If you sign the authorization for use and disclosure, they can be scanned into the system.
So we're not holding on to these paperwork.
But I'm not sure. I mean, it used to be when we did a full ACP session, all of that was scanned into a specific chart that was identified to you. But I don't know what that process is now.
We don't have that with the new EMR, we don't hold them. We looked at just a lot of HIPAA information that we're keeping for people that are not on our services or accessing us. And we basically just want to provide the service and then have you keep your forms for you.
Okay, yeah, so that's a recent change.
Yeah.
Well, thank you very much.
You're welcome.
I really appreciate it. Very informative.
You're welcome.
Thank you. Sorry.
And in the event that you want to do more, that you really want to sit down and do more, Haven can arrange a one-on-one session
Okay,
for you also.
okay, great.
Yeah,
Thank you so much. Sorry we have to leave.
it's okay. We
Have somebody
understand.
waiting for us, so.
Thank you.
Thank you. All right, well,
So if we sign them all out?
If you sign them, you need to complete them. You need to put the information in it. And then if you sign, then they can be witnessed and they're valid immediately.
Yeah.
When I say valid immediately, is they could be used in the event a situation arose. I would encourage you to make copies, yes.